Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's program. On this week's program, we're continuing with our new series entitled AOE, COE, the determination for or against industrial causation. And today we're continuing with part 2 of this program. Now, before we get into today's discussion, I'd just like to review with you some of the ideas that we discussed in part 1 of this program. And in part 1 of this program, we talked about the labor codes, specifically Labor Code 4060 and Labor Code 5402. These are the labor codes that deal with the denied claim. You see, the AOE, COE, industrial causation determination, is not necessary in those claims that have been accepted. Duh! Okay? The AOE, COE determination, the determination for or against industrial causation, is necessary in those cases that have been denied. And it's Labor Code 5402 that is largely responsible for most of the denials that we see as qualified medical evaluators. And then these injured workers, or these allegedly injured workers, then come to us for an evaluation under Labor Code 4060. Labor Code 4060 is the code that governs the so-called compensability examination. And we as qualified medical evaluators have a unique role in the 4060 compensability examination, which is much different than the role we have in the qualified medical evaluation under Labor Code 4061 and 4062, both of which deal largely with disputes over permanent impairment, apportionment, future medical care, and other issues after the examinee has had an accepted claim, has gone through treatment, has been declared to be permanent and stationary, and is now at the end of their claim. On the other hand, the Labor Code 4060, the compensability evaluation, is an evaluation that takes place at the beginning of a claim, that's necessary for the initiation of a claim. Now, let me ask you, what kind of claims would be denied at the initiation, at the initial onset of the claim? What kind of claims? Are claims for injuries that are witnessed injuries, that are reported immediately, that require medical care immediately? Are those types of claims the types of claims that claims administrators deny? No. Claims administrators deny claims that have associated red flags with them. And we're going to talk in great detail today about the reasons that claims become denied. And we'll talk about the unique role of the qualified medical evaluator in evaluating those types of cases that involve denied claims. So that was our first session. We reviewed Labor Codes 4060 and Labor Code 5402. And we'll talk a little bit more about Labor Code 5402 in today's discussion. So in today's discussion, to continue the theme, I want to expand upon the concept of a denied claim, the philosophy of the denied claim. I want to give you the legal and administrative reasons that claims are denied. And then I want to talk about the unique role and the unique perspective that we as qualified medical evaluators need to take into this 4060 compensability exam when we find ourselves face to face with an injured worker who has a claim that has been denied. Now, it's interesting, these denied claims make up a great bulk of the evaluations that we see. And the reason is, the law provides the opportunity for an injured worker or a claimant to receive a medical evaluation in an attempt to prove their claim for industrial injury. Now, I'll repeat this later on in the program, but the Labor Code requires that the injured worker has the burden of proof to prove their claim. And they must prove their claim with a preponderance of evidence. A preponderance of evidence. So when it comes time for us to talk about the role of the qualified medical evaluator in these claims, just remember and keep this concept in mind. for when we get there. It's the injured worker that has the burden to prove their claim. The Qualified Medical Evaluator does not have the burden, and many times the Qualified Medical Evaluator assumes the burden for the injured worker. And that's not our role, and I'm going to give you some guidelines as to how to proceed in these cases so it's not perceived that you're advocating for the injured worker, that you're assuming the burden for the injured worker, which we're not required or expected to do. Okay? So that's our agenda for today. We're going to talk about the role of the claims administrator in the denied claim, and I'm going to take you into the shoes of a claims administrator so that you can see things from their perspective for just a moment and understand why it is that claims administrators deny claims in the first place. And then we'll jump back into the shoes of the Qualified Medical Evaluator, and we'll talk about how to handle these cases and how to interview these examinees in the case of a denied claim. Now, for today's material, I've sent you a link to Labor Codes 3600. I've also sent you a link for the 2016 Physician's Guide, which we'll refer to here in today's discussion. So I'll give you a minute to go ahead and retrieve those resources and references, and I'll collect those up myself. And I look forward to being back with you here in just a moment as we talk today about the conditions of compensation liability and the red flag reasons for denial of injury claims. So I look forward to being back with you here in just a few moments. Okay, I'm back with you now and have my references here with me. I hope you have your references with you as well, because I think it's important that you lay your own eyes on these references as we go through these specific quotes from the Labor Code and also from the 2016 Physician's Guide. So let's begin, and let's talk about the denied claim. Let me ask you, why would a claims administrator deny a claim? Well, we're going to go into both the legal and administrative reasons as to why claims come to us denied. But before we get to that, let's talk about cases and claims that are accepted. And Labor Code 3600, which I have here in front of me, gives us what we refer to as the conditions of compensation liability. What types of conditions have to exist for liability to be accepted for an injury claim? Well, Labor Code sections 1, 2, and 3 tell us what conditions must be present. Number 1, at the time of the injury, both the employer and the employee are subject to the compensation provisions of this division. What that means is that there's an employment relationship between the injured worker claimant and the employer. There has to be an employment relationship. Okay? Number 2, where at the time of the injury, the employee is performing service growing out of and incidental to his or her employment and is acting within the course of his or her employment. That's the AOE and COE that we commonly refer to. Let me reread that. It says, where at the time of the injury, the employee is performing service growing out of and incidental to his or her employment. That's AOE, arising out of employment, and is acting within the course of his or her employment. And that's the COE portion of the AOE COE. And then number 3, where the injury is proximately caused by the employment, either with or without negligence. And it's interesting, the workers' compensation system is a system that provides for benefits with or without negligence on the part of either party. So those are our three conditions. If those three conditions can be met, then these cases and these claims for injury become quickly accepted by the claims administrator with no red flags, with no delay, and with no controversy. Well, what kind of legal reasons under the Labor Code do claims administrators rely upon to deny claims? Okay, let's talk about the legal reasons for claims denial, and then we'll talk about some administrative reasons for claims denial as well. So on a legal basis, the claims administrator can deny claims even if those three conditions are met. They can deny claims where the injury is caused by the intoxication by alcohol or the unlawful use of a controlled substance of the injured employee. As used in this paragraph, controlled substance shall have the same meaning as prescribed in section such and such of the Health and Safety Code. Now it's going to be interesting to find out what happens now that we've had the passage and the legalization of marijuana as to how marijuana fits into the context of this particular restriction or prohibition on the acceptance of an injury claim. Number two, where the injury is not intentionally self-inflicted. And let me ask you, have you ever had an examinee who you suspected had self-inflicted injury in order to obtain workers' compensation benefits? This applies to injured workers who have a pre-existing condition. They know they require medical treatment for that condition, and therefore they inflict injury or they report injury for a condition that already exists so that they can obtain medical benefits, or I should say medical treatment. They intentionally self-inflict injury, or they inflict a situation at work that could conceivably cause the injury that they claim. Examples include stepping off of curbs, falling out of dumpsters, tripping over elevations and the flooring surfaces. In other words, these are situations that I've had in my own experience where employees have inflicted upon themselves in order to claim injury for conditions that they have pre-existing. Number three, where the employee has not willfully and deliberately caused his or her own death. Number four, where the injury does not arise out of an altercation in which the injured employee is the initial physical aggressor. If there's a fight at the workplace and there are injuries sustained, only the employee who is acting defensively in self-defense is entitled to benefits. The initial physical aggressor, no matter how badly they get hurt, is not entitled to compensation benefits. Where the injury is not caused by the commission of a felony or a crime which is punishable, and he or she has been convicted of that crime, this type of employee is not entitled to compensation benefits. Number six, where the injury does not arise out of voluntary participation in any off-duty recreational, social, or athletic activity not constituting part of the employee's work-related duties. So, for example, at the company picnic, if the employee is playing in a softball game and suffers injury at the company picnic, voluntary participation in an off-duty recreational, social, or athletic activity, these are not considered compensable injuries. And then finally, and this is the situation that seems to happen tenfold compared to the others, is the so-called post-termination claims. These are not subject to compensation liability. So the Labor Code specifically says, where the claim for compensation is filed after notice of termination or layoff, including voluntary layoff, and I just myself had a case that involved a voluntary layoff where the claimant, the employee, suffered injury on a non-industrial basis at home, and because of those injuries, never returned to work. In other words, she took a voluntary layoff and then subsequently filed a claim for retroactive cumulative trauma. Okay? So these cases are quite common. So where the claim for compensation is filed after notice of termination or layoff, including a voluntary layoff, and the claim is for an injury occurring prior to the time of notice of termination or layoff, no compensation shall be paid unless the employee demonstrates by a preponderance of evidence that one or more of the conditions apply. This is the post-termination claim. Post-termination claims can only fly if the following conditions are met. Number one, the employer has notice of the injury prior to the notice of termination or layoff. Number two, the employee's medical records existing prior to the notice of termination or layoff contain evidence of the injury. And I just had this case as well, where the injured employee was a full-time hairstylist for a large commercial salon, and she took a voluntary layoff on, say, for example, November 1st, 2014. I'm making this date up. And the medical records existing before November 1st, 2014 with her primary care physician under her private health insurance had numerous documentations of ongoing cumulative trauma, musculoskeletal conditions. And so in that case, the medical records before the termination or layoff did prove her claim for industrial injury. Now, in the majority of cases, these post-termination claims, there are no medical records. There are no medical records existing prior to the termination or layoff, or existing prior to the notice of termination or layoff, to support a claim for industrial injury. And the law specifically prevents compensation unless those two unique circumstances can be met. Number one, that the employer has notice of the injury prior to the termination or layoff, or two, that the medical records prior to termination or layoff show evidence of the injury. Okay? And the reason for the denial of post-termination claims is because the legislators that passed this law realize that employees who file claims for injury post-termination are simply trying to retaliate against the employer. And the law prevents that, except in very unique circumstances that indicate that indeed a bona fide injury does exist. Okay? So these are the legal reasons that claims administrators use to deny claims. If these situations exist, the law simply prevents for compensation for these types of injuries. Now, what about other administrative reasons that claims administrators can use to deny claims? And I'm going to submit to you that it's the administrative reasons that I'm going to share with you in just a minute that represent the bulk of the denied cases that we see. And these administrative reasons have to do with what we refer to as red flags for workers' compensation fraud. These are situations that the employee, the injured employee, presents with that cause the claims administrator to raise their eyebrow and to be suspicious for a fraudulent claim. Now, the presence of any one, two, or even multiples of these red flags do not for certain signify that a fraudulent situation exists, but they strongly suggest the possibility of a fraudulent injury. Okay, so I want you to be aware of these because these are going to come up time and time again in those cases that we get that involve denied claims. That's why the claims are denied. is because the claims administrator has identified suspicious red flags. Okay? Now, I have several sources of these red flags that I want to share with you. The first one comes from the Zenith Insurance Company. The second one comes from an online reference known as Pursuit Magazine. And then the third one that I want to share with you comes from the North Dakota Workforce Safety and Insurance Institute. And it's amazing because they all talk about the same red flags. So I want to share with you what each of these sources and references cite as the most common red flags suggestive of workers' compensation fraud. Okay? Okay, so number one red flag is, number one, an unwitnessed incident. All three of these references refer to an unwitnessed incident, or specifically, there are no witnesses to the injury, or the only witnesses are the claimant's close co-workers. Okay? So, always be on the alert and always ask your examinee. First question, was this a witnessed incident? If the answer to this question is no, then you know right away that the occurrence or the non-occurrence of an industrial injury is not a medical determination. It's a question of fact. Did it occur? Did it not occur? We don't know. We weren't there. There were no witnesses. It's simply the employee's testimony that an injury occurred. And I'll share with you in just a little bit exactly how to handle this situation. But remember that these situations of an unwitnessed incident are merely questions of fact. Well, who is it that resolves questions of fact? It's the trier of fact, which is the judge. It's not you as the qualified medical evaluator. You don't resolve questions of fact. The judge resolves questions of facts. So what's your role in these cases that involve unwitnessed incidences? And we'll go over that here in just a couple minutes. Number two red flag. The report of the injury is not timely. The first notification of injury or claim is made after the employee is terminated or layoff. That's an example of an untimely reporting. What about the examinee who comes into work on Monday morning and reports an injury that occurred the previous Friday before the weekend? Okay, this is an example of untimely or delayed in reporting. Pursuit Magazine says that the injury occurs on a Friday, or is reported to have occurred on a Friday, but is not reported until the following Monday, or the injury happens early Monday morning or at the beginning of a weekly shift, of a weekly work shift. This could indicate that the claimant was injured over the weekend, participating in home activities, sports activities, recreational activities. 1,000 possible things take place throughout the 48 hours that constitute the weekend. Okay? So, first two red flags: an unwitnessed incident with a delay in reporting. Other red flags is that the accident or illness is not associated with the employee's customary job duties. The accident or illness is in a work area that's usually not frequented by the employee. Other red flags, more common of the red flags: the employee is injured prior to a strike, prior to a company layoff, prior to termination, or prior to the employer closing or relocating the business. The employee is injured after giving notice that they're going to be terminating or concluding their employment with the company. Another red flag is that the claimant or employee is already having financial difficulties. And I'm reminded of a case that I had that involved an injured worker trucker who filed a claim for workers' compensation benefits 1 week 1 week after he received notice that his paycheck was going to be heavily, attached for back due and overdue child support payments. His paycheck was going to be reduced by about 60% in order for him to reasonably catch up on back and overdue child support payments. And this was a situation that he realized he simply could not afford, and therefore he found his only recourse was to file a claim for workers' compensation benefits. And it was found later that there was no injury suffered, and that the employee was simply fabricating his claim for an injury in order to somehow, some way, get out from underneath the burden of these child support payments. Okay? So these are some red flags, and there are many more. There are many more. There's as many as 60, 80, 100 published red flags. One of my references here that I shared with you has 60 red flags that are suggestive of workers' compensation fraud. And we see these circumstances all the time. Now, when the claims administrator identifies these situations, these red flags, specifically and especially the unwitnessed incident that involves a delay in reporting, they immediately stamp a denial on the claim under Labor Code 5402 in order to stop the bleeding from the $10,000 while the claim is investigated. And they have up to 90 days to either accept or reject the claim. Up to 90 days investigation period. So when red flags are present, they simply deny the claim. Well, when the claim then comes to us as a qualified medical evaluator under Labor Code 4060 for the compensability exam, what is the role? What is our role as the qualified medical evaluator in these cases? Remember that under Labor Code 3600, the employee has the burden of proof to demonstrate by a preponderance of evidence, that the injury is reasonably caused by their work activities. So let's talk about the qualified medical evaluator's role. And let me ask you, in considering your role in providing an AOE, COE determination in these cases, what is the minimum evidence that you would require as a qualified medical evaluator? What's the minimum evidence that you would require the employee, the injured worker, the applicant, the claimant, to bring to you as evidence? The law says that the injured worker has the burden of proof to prove their claim by a preponderance of evidence. Preponderance of evidence. So, what is your minimum preponderance, doctor? What is the minimum amount of evidence that the employee should bring to you, that you would demand that they bring to you in order to prove their claim? What's your minimum? Now, most examinees come to the evaluation with no evidence. They simply come with their subjective testimony. And we know that in the AMA guides, some references in the AMA guides themselves tell us that as many as 50% of our cases involve examinees who exaggerate claims, that fabricate claims, that malinger claims. And these are references from Chapter 18 that I've talked about in other programs. But we know from research cited in the AMA guides themselves that as many as 50% of applicants exaggerate and fabricate claims. So, what is the minimum evidence that you would require the employee bring to your evaluation to prove their claim? How about some documents? What type of documents? How about a statement from witnesses? In the absence of statements from witnesses, you can assume that for all intents and purposes within reasonable medical probability, the incident was unwitnessed. If the employee claims that there was a witness, such as what this one reference refers to, as their closest co-workers, wouldn't it be appropriate that the injured worker bring to you a statement from the witness? In the absence of a statement from the witness, you can assume that this incident was unwitnessed. What other minimum evidence would you require? How about a DWC-1 claim form? How about their copy of the DWC-1 claim form? Okay, most employees know that in the event of an industrial injury, they are to report the incident immediately, right? Most job sites have staff meetings that talk about the procedures involved with reporting industrial injuries, and I've been at these, and most supervisors will say things similar to the following: I don't care how small the injury, I don't care if it's just a hangnail, we want you to report it immediately, right? How about some sort of a document that they reported it? How about their copy of a note that they wrote to the supervisor? How about something, any document that demonstrates that they timely reported the injury or incident? How about that? Should that be included in your minimum evidence that you require the employee bring in order to prove their claim? What other evidence? What are your minimums? I ask this as a rhetoric question because most times these employees come to the QME evaluation with only simply their testimony. They bring no evidence. And in the absence of evidence, that's the reason the claims administrator denies the claim. Because the employee has no evidence that an injury actually occurred other than their testimony. So this is a rhetoric question, but I want to ask you to start to consider the minimum evidence above and beyond the injured worker's testimony that you would consider significant in proving their claim for industrial injury. Okay? So your role in these evaluations is to, number one, determine the presence or absence of a bona fide condition. Okay? Does a bona fide condition exist? What is that bona fide condition? And number two, if a bona fide condition does exist, in other words, if there is pathology, does the injured worker present with pathology? If there is pathology, is it possible that that pathology could be the result of an industrial injury to have occurred in the manner that the injured worker reported it to have occurred? Okay? So let me repeat that. In these cases that involve denied claims, these cases come to us under Labor Code 4060. This is what's referred to as the compensability exam. Now, can you as the Qualified Medical Evaluator state within reasonable medical probability that an industrial injury occurred? No, you cannot state that. You don't know that because you weren't there, and in cases of denied claims, the occurrence or non-occurrence of an industrial injury is a question of fact. It's not a medical determination. So these questions of fact are not resolved by us. They're resolved by the trier of fact, which is the judge. So what's our role? Our role is to provide the trier of fact with some information upon which he can rely. And that includes, number one, is there a bona fide condition? In other words, does the applicant, the injured worker, actually have pathology? Do they have a condition? Do they have a diagnosable disorder? Right? The quickest way and the easiest way to deny all claims is to fail to identify pathology. These are injured workers that provide for us a totally normal exam. Okay? Does a bona fide condition exist? And number two, if a bona fide condition exists, which I'm going to tell you many times, most times, pathology exists. That's why injured workers come to the evaluation, because they have pathology, because they know they need medical treatment, and because they're seeking benefits. So if a bona fide condition exists, the number two information that we need to provide to the trier of fact is it possible that this pathology could be the result of an industrial injury to have occurred in the manner that the injured worker reported it to have occurred. And it's only when these two conditions are met, number one, that pathology exists, and number two, when that pathology could have occurred in the manner that the injured worker reported it to have occurred, can we, as the qualified medical evaluator, opine for an industrial injury. And again, even though we opine within reasonable medical probability for an industrial injury, ultimately it's the trier of fact that resolves the question of fact, which is the occurrence or the non-occurrence of the injury. The occurrence or non-occurrence of an injury, to repeat myself, is not a medical determination. It's a question of fact. And we as qualified medical evaluators do not resolve questions of fact. We simply provide the trier of fact with two pieces of information: presence or absence of pathology, and the likelihood within reasonable medical probability that that pathology could have been resulted from an injury to have occurred the way that the claimant reported the injury to have occurred. And that's our only role as qualified medical evaluators. Now, let me conclude today's discussion by saying that in opining for an industrial injury, remember, it's the injured worker that has the burden of proof to prove their claim. It's not the qualified medical evaluator that proves or disproves the claim. So the injured worker should strongly prove their claim to us in order for us to opine for industrial injury. And I just want to leave you with the thought-provoking question as to how and what type of information the injured worker provides to us in proving their claim. What are your minimum standards of evidence that you would require before you put your seal of approval in opining for an industrial injury? And that's a rhetoric question, doctors, that only you can answer. And that's something that you need to take a deep look at your philosophy and your ethics with regards to these denied claims. So, doctors, I hope this helps you. And there are no correct responses in the question as to did an industrial injury occur or did an industrial injury not occur. We simply answer these questions within reasonable medical probability, taking all information that we have available to us into consideration. And many doctors are comfortable opining for industrial injury when they have sufficient data, and many doctors are comfortable opining against industrial injury when there is insufficient data upon which to prove an injury claim. So doctors, I hope this helps you understand the nature of denied claims and why it is that we receive so many evaluations to resolve the compensability issues with denied claims. And in our very next session, I'm going to take you through an algorithm process to help you come to the bottom line conclusion, and for that conclusion to be correct 99.99% of the time with all your cases from here forward. So I look forward to being with you in our very next session. It's been my pleasure to be with you here today. And for now, this is Dr. Perry Carpenter, wishing you best of success in your career as a qualified medical evaluator.